that what is going around on the media and social media, that invitation, I came to know the topic is changed. So I'm sorry, I'll be boring you with a little of both. Uh, and excuse me, a very apt description of the courtcraft has been given, quoting that intricate dance of persuasion. Are true. But let me also tell you that there is no pill, there is no bhutti that anybody can give you so that you start. Now, unfortunately, over the years, this is what I feel. I may be wrong, I hope I'm wrong, that people have stopped reading. Just like I've observed with my children and grandchildren, writing skills have fallen. You know, when we were in school, I remember my boarding school days, every little thing that we wanted, we had to write home and request our parents and ask for it, or teachers, or whatever it was. And letter writing was one very essential thing that we learned how to write and express. Now, in court also, what you do is you will express. The more you read, of course, law books and journals, etc. But otherwise, also you should inculcate an habit of reading. The maximum that you can read, the more you will know, the more it will be at the back of your mind, and someday it will come to your use in some case, whether it be politics, history, geography, anything. You never know what will come of use to you. So I would request each one of you to be more academic. Today's world, of course, you have the advantage of technology, your computers, your mobile, and everything. SMS, I think, is a very good thing, SMS and messaging. But that is one thing which I think has harmed our learning and expression. If you have to message somebody, you just say coming, or you some sort of all these short forms that you have on SMS. I also get lost when I receive messages from my children or grandchildren. You know, I have to figure it out what they actually mean. Now, these are things, of course, short form to be brief is good, but then, you know, expression should be there. What I'm only trying to emphasize that you should have expression. And the more you read, the better will be your expression. Now, before I get into the nitty-gritties of courtcraft, the little that I can help you with, speaking on these topics, and of course, courtcraft would, in my thinking, include a bit of dress, some etiquette, and ethics. Now, often we try to pull a fast one on the judge. It's all right so long as you get away with it. I remember there used to be one senior lawyer when we joined, and go home and then get hold of the book, or to the library and get hold of the book. And when you opened that page, you found it was something entirely different. Later on, we realized that the senior counsel used to just, throw judgments at the judge. Yes, they knew, of course, what he was doing, and they also knew that this gentleman had this habit, so they used to also let it pass. But people like us used to get befooled a bit till we caught on to what it was. Now you can do this thing once or twice, but if people catch on to what you do, then there will come a stage when everything you say, the judge will start taking with a pinch of salt. So don't let that reputation build around you. Don't let the judge know that you don't read, you just come and throw things. Now, so far as a few things I will say about the original topic that was given to me, which I think, having got this opportunity, I'll bore you with it. I confess I am old-fashioned, traditional, and some may even say I have archaic thoughts. And even at the risk of gaining annoyance of some, Madam will excuse me if I say something which is not palatable. Uh, the old ways that were there that made our profession so great. If you go into history, recall the entire freedom movement, whether it was Gandhiji, Sardar Patel, Dr. Rajendra Prasad, Nehruji, Dr. Ambedkar, they were all from the legal profession. Why? Everywhere leaders of society were from the legal profession. Why? Because it was the lawyers, the advocates, the mukhtars, wherever they were, from the Mufassil towns to the seats of the high courts, they were the people who used to, well, they were learned people. They used to read, they used to keep abreast of the news, radio, and whatever. They had the means also. But they were the knowledgeable people and they shared their knowledge and used it. They had a thinking which they used and then became natural leaders of society. Unfortunately, in our profession, as academics went down, as like in many other fields, there came a stage when our profession reached its nadir. Things went down and people became worried. Now, mercifully, the tide has changed. Today, with these, and that was, I think, primarily because of the education system which was faltering. It was not the young person's fault, it was the education system which was faltering. That's what I think. Now, today, with these law schools and all, and good education, good law education, you have the best minds voluntarily of their own vocation coming to this profession and doing well. These law schools, the students are fantastic. Even they have certain drawbacks. Drawbacks in the sense that they seem to be a bit confused whether they want to come into the profession and practice in courts or they want to go into these law firms which give them a lot of money and from the initial stage, and they basically become, as I see it, dignified clerks, and they remain that because they have a set routine. I'm not derogating it, please don't take it that way, but then they don't have the excitement of our profession, the excitement that we face in courts and the opportunities that we have in courts, that they don't get. They have a more, after some time, some of them I've been talking to, they do get bored with what they are doing in the office. Earlier it was, our profession, it was said that only people who have something to carry them over, who have something to survive from support from home for 4-5 years or more, they can only survive in the profession. Thankfully today things have changed and young people from all sections of society are coming in and doing very well, and I hope it remains that way. Now the Advocates Act provides bodies in the form of the Bar Council of India and the state bar councils which have made rules under Part 4, Chapter 2. Now this deals with almost all aspects of our profession, and ours is said to be a gentleman's profession. Grievance to the proper authorities. Now this, when it says it shall not be servile, it really means we should not be servile, but at the same time, remember, we should not be acting in a manner or behaving in a manner that is improper. Use temperate language. Your body language also must be appropriate. Don't be aggressive. Be firm, but don't be aggressive. And don't be servile. Sometimes, with due pardon to madam, you find lawyers unnecessarily 15 कर रहे हैं, झुक रहे हैं, trying to be, be servant, showing yourself how humble you are when you are actually not. Be polite, be gentle, be well mannered. Unnecessary saying, lordship, how great you are. It's not that. He is one of us. Unfortunately, another thing today that's happened, when we joined, it was always us. There was a lot of bonhomie between lawyers and judges. And in fact, on a social level also, it was the judges only mixed with lawyers. They didn't go around much in society those days. And they have something called a blue book or something, I don't know. So there are certain ways and how they are to conduct themselves. And it all boiled down to it was the lawyers and the judges who used to interact. Somehow over the years, there's some gap that has come about, and we even hear of things like us and them lawyers. Now, this is unfortunate. It should not happen. I remember Justice Aftab Alam. He was one who was always at one with the lawyers. On one occasion, there was some function going on in the lawn in front, and there were some seating arrangements made, as often happens, judges ek taraf, lawyers ek taraf. And somebody commented. Immediately he got up and came and sat with the lawyers, and then other judges also came and sat with the lawyers, and it was matter was diffused at that time. But yes, we should realize that judges are because of us. The respect that you have in the Patna High Court for judges, I have not seen it anywhere else. जितना judges के लिए respect we have or the people have in Patna, that kind of a thing is not there anywhere else. Whether it is the staff, it is the lawyers, it is anybody. And why? Because we have created a halo around the judges, and the judges also understand this. That's why they in turn have affection for the lawyers, and they have a place in their heart for the lawyers. Exceptions are always there. But this thing should continue, and we should, that bonhomie should be there that was there in the past. I'm sorry I digressed. Now, Rule 2 to 10 lays down the do's and don'ts of an advocate. Clause 11 to 32 lay down the do's and don'ts for an advocate vis-a-vis his client. Rule 33 states an advocate who has any time advised in connection with the institution of the suit, appeal or other matter shall not act, appear or plead for the opposite party. Rule 34 and 35 deal with the duty to the opponent. Now this is one important thing and which comes in the courtcraft. Often we see lawyers playing tricks with each other. It's unfortunate. You don't serve them copies in advance, you don't serve them this, you avoid, sometimes you deliberately have pages missing. Now all these things irks the judges ultimately. And because proceedings are held up because of these things, the other fellow says, sorry, I have not been given a copy, or the copy given is illegible or whatever. In those days when we have typed copies, then the fifth typed copy or the sixth typed copy, which was virtually illegible, used to be kept for the other side's lawyer. And this complaint used to be constant. Now with computers that has gone, but then all these things, small things ultimately add up to how you perform in court. Then there is Rule 36, which specifies the duties to colleagues, and Rule 39 states that an advocate shall not enter appearances in any case in which there is vakalatnama or memo of appearance filed by an advocate engaged for the party except with his consent. Now this is something is not only part of ethics, it's also part of court behavior. If some counsel has filed his vakalatnama, has appeared in a case, please don't, what we say is brief hunting, brief grabbing. Don't try to do it. If something turns out, if the client wants you to appear, please take his consent. Unless there was a situation where the client was adamant, no, I will not have X, I will go for Y or somebody else. But normally, no objection wala is not considered a good thing. At least in those days, the judges used to frown on it. Breach of the rules or any misconduct on the part of advocates goes before the State Bar Council and appeal before the Bar Council of India, which are governing and also disciplinary bodies and deal with, and the discipline is dealt with in the manner laid down. In other words, our representative body enforces discipline, we enforce discipline on ourselves. Today one gets to see all kinds of soliciting and advertisement through media channels. Now this is something which is prohibited for us. We are not to solicit clients, we are not to advertise. But today in the social media it is there. Rule 36 lays down what you can disseminate, the information about yourself that you can disseminate. Anything more than that is a breach of the rules. And of course, it is a misconduct which can come under mischief of Rule 35. Now, having pointed out these things, I come to the next and probably the most hazardous part of my original brief is to tell you how to and how not to dress. Now, I would only say that, of course, how you come dressed to court will impact on your performance. The judge will observe you. If you are dressed in a weird manner, it doesn't go down well. Now, a task which is inherently risky for any person is to tell a lady how or how not to dress. So I request all of you to go through chapter 4, forms of dresses to be worn by advocates. These are rules under section 49 1GG of the Act. I sometimes do wonder why we do not wear Indian dresses permissible. It is more suited to our climate, it is more hygienic. I remember Mr. Late B.C. Ghosh, the great man that he was, he used to always wear a dhoti to court. In South India, there are judges and lawyers who still wear a dhoti to court. What we say lungi, they call it dhoti. In the Supreme Court, late Anand and Mullah used to go to court in Achkan Pajama. Over here also, I think 2 gentlemen come to court in Achkan Pajama. Now, we should, there's no harm, we should go in for our own dresses. Another essential part of courtcraft is court manners and etiquette. You often find people sitting in the courtroom, fidgeting around, shifting from one chair to another, or gossiping, or doing things like that. Please remember, most judges will observe this, and many of them don't like it, some detest it. Sitting at the back, you can whisper a bit, you can talk a bit, whisper and this thing, but avoid. Because bad manners is never liked by anyone, much less a judge who is presiding over the proceedings. Avoid doing all that. And it also disturbs the judge as well as the counsels who are on legs. If people are talking at the back, it does disturb. How do we address our judges? That is also a thing which has come up. We are still going with our colonial legacy, lordships and lords, which is something which was replicated by the Supreme Court, which has, and even the rules have been amended with the insertion of Chapter 3A. Now, Chapter 3A says, High Court and Supreme Court judges are to be addressed as Your Honor, and the lower judiciary and tribunals have been left to the choice of the councils. You have to be respectful, be very respectful. But it is not compulsory that you address, of course, there are some of us who may find it difficult to carry on without saying Lordship, Lordship. The other day also, the present Chief Justice, he he tokoed, if I can use that word, counsel. What are you doing, Lordship, Lordship? Carry on, say what you want to say. Itna Lordship, Lordship mat kariye. Now that is something which is, you know, they say that there are some of us who may not have anything to say other than lordship. These things are apart. It is better that if we uh, take it upon ourselves to change these archaic ways. Of course, some of the judges may not like it, and you risk annoyance because you are there to get some relief for your client, and if the judge is annoyed, then well, that much is against you.
With, I should rather say, when I joined the profession, uh, Madam Nilu was there. We could see her. There were few more. I believe Justice Seema Ali Khan, she is no more with us, and Justice Sanjana Prakash. They two of them were there when Nilu was also there. So this is how I started. I believe I could see only few ladies when I had joined the profession. And Mr. Singh had been guiding you all so much on the court crafts. Rather, I would say he was very right. And instead of going through different sections, what he went through, I would suggest all of you that please go through the Advocates Act and the High Court rules. These are the two books which at the initial stage when we joined the profession, these were the two books which we were actually asked to go through before we could go through any brief or any application or anything what we had at the initial stage. So I would ask all of you that first please go through the Advocates Act and look into what all are the provisions for the advocates. Now, as soon as you go through that, you could come across that what is the courtcraft, because that is into that what we are required to wear. That is also very important. We were said when we joined the profession that how you are required to look, what all are the dresses. बीच में काफ़ी issues भी हुआ था when we females were not wearing collars with our dresses. And thereafter we made it a point, we went through the Advocates Act, we went through those High Court rules where we could get at what we are required to dress, how we are required to dress. So that is also one of the major aspects. The second, what I could say that yes, while appearing before the judge, they all are among us. I can share one of my experiences when I joined the bar. Immediately thereafter, I had engaged one of the judges, then counsel obviously. And immediately, I think after a month types, he was elevated. I had absolutely no clue that the judges are elevated from among us. So it was just, I was so raw, with no background, nothing. I am the first generation lawyer. I knew nothing actually about this profession. So it was such a situation, I just went running inside the courtroom just to see, acha, ye judge ban gaye, aisa bhi hota hai kya? So this was the expression. And I remember it very vividly because it happened, I met him right now a month back in Delhi. And he very nicely said, smiling, Nivedita ko dekhkar nahi lagta hai that we are now superannuated. So it was otherwise. I thought that he is going to say that now she is so old I could realize my age. But it was otherwise. Anyways, that was a compliment. I took it very, very broadly. What I would say, so Mr. Singh was absolutely correct that they are among us. Like even today when we meet Nilu, it's less that she is a judge, more that she is Nilu among us. So this is how the kind of relationship we had been, and this is the kind of relationship actually we have accepted, we had been there. So I think थोड़ा सा deviations हुआ है, थोड़ा सा changes हुआ है. हो सकता है कि आप लोग के बीच में all those who are sitting there will be addressing them as honorable judges. Maybe tomorrow, maybe after some time, maybe in our later stage of life, we'll be doing that. So once they are at that side, and there's one more aspect, people generally who are not from this profession would not understand that once the judges who are from among us, who are elevated, people do not understand that when they sit on that chair, we just forget that any kind of relationship which we were carrying with them before their elevation. Yes, as soon as they get down off their foot, we'll start understanding and recognizing that yes, she was our such and such. Maybe we were sharing the lunch boxes, maybe we were cracking silly jokes, whatever, that is there. But once they are there, this nobody understands the decorum of our profession which we have. You may be elevated tomorrow, today I call you X, Y, Z, but tomorrow you are just the honorable judge when you are sitting there. So that is the decorum which we maintain while we are into this profession. We don't tell our clients that he or she was my bosom friend, very close to me. We don't go and say, we don't take that, in fact, that references we never give, that XYZ was very close to us. So this is also one of the decorum of our profession. What we maintain, we were maintaining it yesterday and we maintain it even today. I wish we maintain this in the future also. Now the second aspect, although I have not worked out, but yes, what I could speak on my experience is that young days में लोग काफ़ी aggressive रहता है. Aggressiveness does not work, isn't it, Nivedita? We all were aggressive. Now with the lapse of time, we have understood that aggressiveness does not work. Yes, we should be, as it was told, that yes, we should be very firm while we are arguing or we are representing our matter. But before we say this, that we should be firm, this firmness comes from the fact that we are very well prepared in our briefs. Till we are very well prepared in our brief, it is not possible that we can be firm about anything. Because if we are well read, the judge may put you some question. Say for example, when was the complaint filed? You would shiver, yes, my lord, I am looking. No, it's only when you are ready with your date of events, when you are preparing your cases, right from the first. My senior taught me name of informant, date of occurrence, place of occurrence, date of FIR. This is how you prepare your notes. So this is when you prepare, you are so firm with the basic questions. The question may not arise while you are addressing the court. It may not be a case that yes, you may not be required even though you are ready. But once you are ready, you will feel that the confidence would be from within. And you can very confidently, you can argue your matter. So don't lack your confidence. Being humble does not mean that you lack your confidence. You shiver when the judge is saying something, hum log dar gaye, hum log chup ho gaye. No, it's not like that. He's also a human being. He may also commit some errors. He may also have some, may not be knowing certain things. So I believe we all see these in our daily, this thing. That the judges even say that, look, you leave the file, I'll go through the file, and this matter would be posted tomorrow or day after. So this is even, they are human beings, they are from among us, so there is nothing to be scared out of when you are appearing before the judge. Why am I saying? Most of the girls, when I find them appearing, they are so low, they are not even audible. They are literally andar se dara hua hai log. I am appearing before the judge. No, you are not required. I remember Nilu pure jor se. So Nilu used to argue very forcefully because she must be ready in her brief. It's not that, और ये तभी होगा जब हम लोग तैयार रहेंगे केसेस में. हम लोग भी अभी जो केसेस में तैयार नहीं होते हैं, उस केस में सोचते हैं कुछ टाइम वाइम हो जाता जो ज़्यादा अच्छा रहता, पढ़े तो है नहीं इसको. So it is only when we have not read the brief. So this is another aspect of the matter. I say be courteous. I will not comment on so many other things, but I would surely say that once you are prepared, everybody is going to recognize you. This Women Federation, I always believe in one thing. It's very good that this federation has started. But at the same time, I would say that this federation would not give us advantage so far as our professional aspect is concerned. We may be one. We may be one at a stage when we need the help of each other at a different platform where we require each other. But so far as the professional aspect is concerned, it is only the skill which has to be developed of your own. You should have your own brief, you should have to read your own brief, you have to be ready in your brief, you have to be humble to the judges, you have to be respectful to the judges, you have to be respectful to your colleagues. This is how I believe that the profession starts, and this is where I think that the profession ends.
Punches. It's so nice. मेरी तो आंखें जब मैंने प्रैक्टिस ज्वाइन किया था तो lady lawyers were counted on fingers. So I always feel happy seeing around all of you and coming up every day increasing. So much has been said by Dr. Singh and Nivedita, but I would like to add, of course, elaborating on it, that the way courtcraft is the tact of a lawyer. It is not a deceitful tact. It is a tact, a diplomatic tact, how you should conduct yourself. It is a conduct which is very important. Supposing the first step is you are coming to the court room, your persona, your demeanor, how should it be? You should be dressed properly, decent, neat and clean, prim and proper, and you should, the way you sit, everything, the judge 2.5 feet ऊपर से सब देख रहे हैं. He is also listening, he or she is also listening to the matter which is argued. He or she is also looking at all the audience which is before him or her. So any new face is one raises an eyebrow कि वो नया है, नहीं है. So you are being very closely watched, even afterwards also, because everything can be seen from a little hilltop. So your whole mannerism, your whole demeanor, your whole persona is being watched all the time. And not only in court, I would say your entire personality is very important, the way you behave, the way you conduct, because you are a respectable citizen of society. The society also looks up to you. You are in a noble profession. So the demeanor is most important, the persona is very important. Now I come to how you argue. The way you argue, it should be strong and assertive. It should be like it is your case, your client's case. You are not going to win the argument, you are going to win the case. That should always be in mind. So it should not be meek, it should neither be loud, but it should be strong and assertive. And of course, if the judge asks certain query, without hearing, as Dr. Singh had rightly pointed out, you should hear what is the query and then answer it. And of course, one of the lawyers, while I was practicing, he commented, he was my male colleague, he commented, whenever you argue as if you are entitled. You argue by way of entitlement. So that entitlement word is very important.